The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon. My name is Matt Parker. I'm an attorney with Marshall, Parker & Weber, and I am here today to discuss the often asked question about the house you live in. Should you at some point in your life transfer the house to your children? Clients often ask us this question because of some experience they may have had, either with their parents or neighbors. Those folks have at some point transferred their home to their children. So we get the questions about whether or not this should be done, and the reasons clients want to do this range from concerns about nursing home costs to inheritance taxes. So I'm going to go over the pros and cons of considering such a transfer and some suggestions for accomplishing your goal of protecting your home. I am co-presenting today with my coworker, Heather Kohler. She's a longtime case manager with the firm of Marshall, Parker & Weber, and she and I have done a lot of estate planning appointments with clients and have addressed this issue of whether the home should be transferred to a child or whether there are better options for our clients. So feel free to post a question as we go along, and we'll attempt to answer it by the end of the webinar. So let's get to a fact pattern that will put this very issue of transferring the home in some context. Here's a classic fact pattern that we hear a lot in our appointments. We've got Stella and George, a married couple who have owned their home for many years, in this case 40 years. They acquired the home for a very small amount of money, let's just say $5,000, and today it's worth much more. It's now worth over $105,000. And they want to know if they should transfer the home to their kids. We learn that they have 3 children with various issues. Stacy, she's an adult, over 50 years of age, let's say, and she still lives with her parents. She does not have the means to buy her home. She's one of those kids who just hasn't launched for various reasons. She's going to stay with mom and dad for the rest of her days. Carl, he's out in California. He is in a bad marriage and heading for a divorce. Carl's doing well for himself. He's got some resources, but nevertheless, he may be splitting up his assets at some point in the future, as California is I believe a state that divides the assets rather equitably in these divorces. So, Doug, he's got some drug problems. He's just struggled for most of his life, had some issues. And his parents know he owes a lot of money to creditors. And so he's going to have a few judgments against him over the years, and they're concerned about his financial situation. So we've got a case here with some financial dynamics and family dynamics that are not all wine and roses. These facts, of course, are going to play out in our discussion with Stella and George as to whether they should, in fact, be transferring the house to the kids. All right, so Stella explains to me that there are several reasons she believes the home should be transferred to her children. One, she's got a fear of losing the home to nursing home costs. Stella explains to me that her neighbor, Lois, entered a nursing home many years ago, and after some time, Lois's house started to fall apart. There just wasn't the money to keep it going. Then the family of Lois sold the home, and much of the sale proceeds went to pay for Lois's care in the nursing home. And Stella and George are fearful that the home that they've lived in for 40 years and worked to maintain might actually have to be sold and the proceeds paid for either of their costs of care. The second reason that Stella is concerned about protecting the home is that they've heard about these taxes. They call them the death taxes. They don't know much about them, but they've heard that these taxes upon death could consume the value of their home and other property. So they're worried about them. They want to know more about them. And if they can, they'd like to avoid paying a lot of money to the government at the time of their passing. And since Stacy needs a place to live for the rest of her lifetime, Stella wants to give the home to the kids in an effort to protect it for Stacy. But they still don't want to cut out the other boys. I mean, they love them all equally, so they want to protect the home for Stacy while at the same time equalizing their estate, making sure that everybody gets a fair share. So they want to know, how can they do this? How can they protect it for Stacy, make sure Stacy gets the ownership at their death, but also being fair to everybody in the family. With all these issues in mind, Stella and George are still concerned about giving up control and ownership of their home. They have heard stories about people losing their home after the home was transferred to the children, that something happened and they had to be kicked out. I call these the Reader's Digest stories, that something horrible happened to somebody and it's passed down the line, and eventually somebody hears about getting kicked out of their home. So they're also worried about Carl's pending divorce and how that could affect their home. If they put Carl's name on the title to the home, could that get wrapped up in his issues that he's facing out in California? And of course, Doug's creditors are also a concern for them. Could Doug's creditors basically put a lien against the home if they put Doug's name on the deed? So they want to know if there's some way to protect them after the home is transferred. Can they still make sure that their right to live in the home and use and enjoy it is protected? Of course, they also want to make sure the house is protected for daughter Stacy, who will likely need the house to live in after they're gone. They no more want to put the home at risk for their own lives, but also because they want it ultimately used by Stacy after they have passed away. So let's flesh out some of these concerns that Stella and George have raised, starting with their concern about the nursing home costs. They have heard about Lois's situation, and is that the house had to be sold. It certainly sounds like Lois was a widow and had to go into a nursing home, and she lost the value of the house to the cost of her care. Well, the risk of losing your home to nursing home costs is very real. I mean, if you're not a particularly wealthy individual, you might not be able to self-pay for the cost of your care. What a lot of my clients don't realize is that nursing home costs are escalating to the point where they're now on the average of about $10,000 a month in Pennsylvania. And this cost can easily consume the savings of the average couple unless they qualify for a program called Medicaid. And Medicaid has these very complicated rules associated with what assets are available to pay for your care and have to be spent down, and what assets are exempt. In many cases, particularly with a widowed person, they go and enter the nursing home, and eventually the home is sold, and then the proceeds are used to pay for the nursing home care. So if you're married, certainly the home could be sold as well, as in Stella and George's case. But obviously in the case of their neighbor, this was a single person, and the proceeds certainly were paid for the cost of her care. In addition, there is a program called estate recovery, and this is, of course, associated with the Medicaid program, and it does affect the house. Heather deals with Medicaid all the time. She does a lot of Medicaid applications, help people qualify for benefits. You've dealt with this program before. Do you want to explain just a little bit about how the Medicaid estate recovery program works?
Sure. After a person receives Medicaid for nursing home care, the state keeps track of the benefits. At your death, the state will place a lien on your estate. If you still own the home at the time of your death, the home could be sold and the proceeds could be paid to the state for your nursing home care.
Okay, so in Lois's case, the neighbor, she likely entered the nursing home, and that's why the home was falling apart. She wasn't living there anymore. And while she was in the nursing home and on Medicaid, the government was keeping a tab. They were keeping track of all the money they paid towards Lois. And if Lois died owning the home, they put a lien against the house, and there goes the equity in the home. So even though the government doesn't often make you sell the house in order to get Medicaid, they do put a lien at death. And so there's a really big concern if you don't plan with the house ahead of time, and Stella and George are rightfully concerned about this, that it could be exposed to this program. Now, the estate recovery program does tend to affect single people. You have to own the home at the time of your death for this lien to be placed upon it. However, we don't know whether Stella or George will need nursing home care, or maybe one will die first and the other will enter a nursing home. I don't have a crystal ball. They didn't give me one when I graduated from law school, so either one of them could be affected by long-term care, neither one or the other. So it's preferable, if we want to protect the house, do it with the anticipation that one or both of the individuals might need nursing home care in the future. And we should also mention this look-back period. Our clients ask that all the time in these consultations, particularly as it relates to the home. If they want to protect it, they've said, well, I've heard I've got to do something ahead of time. What is this look-back period all about? So Heather, once again, what is this look-back period? And it is part of the Medicaid program, right?
Correct.
Okay.
So if you want to protect your assets, such as your home, from the cost of your care, you need to transfer it 5 years prior to needing the Medicaid benefit. This 5-year period is the look-back period, the time that the state looks back to see what you did with your assets. If you have transferred the house more than 5 years prior, the transfer will not affect your eligibility for Medicaid benefits. So planning ahead makes sense if you want to transfer ownership of an asset, such as your house.
Okay, so very good. We've got a situation here where maybe somebody has developed a dementia and they're about ready to enter the nursing home. If they were to take the home at that time and transfer it to an otherwise healthy child, you would make yourself ineligible for Medicaid because it's done within the 5-year look-back period. But of course, the government says, you can go ahead and transfer your home, and we won't assess any penalty if you do so well in advance. And that is, of course, 5 years at this time. And the other often asked questions is are they considered raising the look-back period to 7 years or some longer period of time? And at the present, they are not. When I started practicing, it was 3 years, and prior to that, there was, in fact, a 2-year look-back. So occasionally, they raise this period of time, and right now it is still 5 years. So if we're counseling Stella and George, we've got to keep this 5-year look-back in mind and say, listen, provided you are healthy, there is the opportunity here to transfer the house and get beyond that look-back period so you can shelter it from being available to pay for the cost of your care in a nursing home. Now, the second fear that Stella and George have is that they're going to lose their home to the so-called death taxes. They believe that there's this tax out there that's going to consume the value of their home at their death. This is not entirely true. It used to be true, let's say more true than it is today, but at this time there is only one inheritance tax that will affect them. That is the tax here in Pennsylvania. Pennsylvania has an inheritance tax on assets like a home, and the rate of tax is 4.5% if the home passes to children or grandchildren. That is anybody down the line. Now, 4.5% is not an enormous tax rate, as tax rates go. That is about $4,700 on a home worth $105,000. So it's certainly not going to consume the entire value of the home at death. So perhaps the death tax is an overrated fear, at least here in Pennsylvania. I think the fear does stem from a tax that used to affect many more of my clients, and that is the federal estate tax. Back when I started practicing law in the late 1990s, the tax issued by the federal government on estates would affect people who had $600,000 or more. And there were a fair number of people out there who had over $600,000 who would be affected by the federal tax. Today, this federal tax only affects people who have $11.2 million or more. So this tax has transformed itself from a tax that affected a large percentage of our population to a tax that affects very few people, only the very wealthy. So we're not as concerned today about the death tax. Pennsylvania's inheritance tax affects all of the assets that you own except life insurance. And it's very difficult to avoid. You have to know when you're going to die and then transfer your assets at least 1 year before then to your children. So it's a tax that is a challenge to avoid. And quite frankly, at 4.5%, it sometimes is not worth giving up control and ownership of every bit of your assets to avoid that tax. The bigger tax that probably affects more of my clients is something called the capital gains tax. And this is a tax on the appreciation in the home. If Stella and George transfer their home to the kids and the kids don't live there and they try to sell the home, they could end up paying a capital gains tax on the property. Given the home has a gain of $100,000 from the point at which Stella and George bought the home, and let's presume, there are no significant improvements or improvements that we can actually trace. So we have a $100,000 gain. That's a 15% tax in most cases on the gain. And that could be a $10,000 to $15,000 capital gains tax that one or more of the kids would have to pay out of their share of the home. So it could end up being a much larger tax that they would have to pay if the kids owned the home and then turned around and sold it. So Stella and George need to think carefully about transferring their home during their lifetime to their kids if they want to limit the type of taxes that they're going to pay. Allow them to inherit the home, well, maybe they pay 4.5% tax. But if they give the home outright to the kids and the kids don't live there, they could end up paying a capital gains tax that is much larger than the inheritance tax. I should point out that if you inherit the property, you're unlikely to pay inheritance capital gains taxes because the rules are you pay one or the other tax. Inherit a property, pay 4.5%. You don't have that capital gains tax to deal with if you turn around and sell the property shortly thereafter. So I tell my clients that this is an either-or situation in most cases. Okay, the last issue we're going to talk about before getting into what are the options for protecting this home are the issues associated with transferring the home to the kids. What I call these are the risks. I abbreviate them as the big D's because they all start with D. What if you transfer the home to the kids? What horrible things could occur? and keep in mind, we at the law firm will deal with many families over the course of the month, and many of those families won't have any of these issues arise, but the other percentage of families will have one or more of these concerns arise with their kids. And as we pointed out, Stella and George do not have kids without issues. They've all got some issues. And so, Heather, why don't we go over each one of these on the screen here? The first one is the death. So what could happen if you transfer your property to the kids? Unlikely, but it does occur in some occasions.
Right. If one of your children owns your home, a child could die, and his or her interest will pass to someone else and be subject to their inheritance tax.
Right. We've seen this tragically happen. Put the kids' names on the title to the property, or maybe a bank account or some other asset, and the child unexpectedly dies. Suddenly there's inheritance tax to be paid because the child has passed away and their interest passes to maybe their spouse or their kids. And maybe somebody else becomes a co-owner in the property that you never intended. So it becomes a very messy situation. Because once you give the property to the kids can, in many cases, decide who's going to inherit their share of the property. If you don't make the property joint with right of survivorship, meaning it goes to the other kids if one of them dies. The other is debt. How does that pan out, particularly in this case?
One of your children or more could be sued or have creditors, and there could be issues with divorce and could subject your home, again, to their creditors.
Yeah, I'm never quite sure, in these cases, my clients come to see me, they have these kids. What if one of them has some massive debt outstanding or gets involved with some creditor problems? A creditor could put a lien on the house, and if the house ever goes up for sale, the creditor could grab that interest that the kid has in the house. They could actually sue to have a partition, meaning they want the money now out of that property. So it could get messy if your kid has creditor issues. And with divorce, I'm never quite sure what states' laws are going to apply. So I don't know how the laws of these various states will affect the claim of the divorcing spouse to the property. Last is dysfunction. How does this play out?
So the kids could have a falling out with you and try to force you out of your home. And if you have no legal right to reside in the house, it's difficult to prevent this from happening once you give ownership of the home to your children.
Yeah, once you turn it over to them and you have no other documented rights as to live in there, it's very difficult to prevent the kids from saying, hey, time to go. We need this property to pay creditors. We've had a falling out with you. We want you out. And greed. Greed, unfortunately, rears its ugly head in many cases. And so there is risk associated with just turning over a property and not having the right sort of some legal right to stay in the property for the rest of your days. So, with all of that happiness, let's talk about some ways in which we can probably accomplish Stella and George's goals without exposing them to those risks, as well as the other issues that they are concerned about. What the popular solution today, particularly with attorneys who do asset protection planning, is to have Stella and George to create a trust for themselves to protect their home. They will transfer ownership or title of the home into the name of their trust. This type of trust is known as an asset protection trust. It helps accomplish a lot of their goals. Here's how it would work. Think of the trust, if you've never dealt with one, as a person on paper. Stella and George sign the trust document, bringing the trust to life. The trust will have its own tax identification number, like people have social security numbers, and the trust can actually own assets like a home, a bank account, some stocks, life insurance, mutual funds. Most of the assets that you own, you can transfer to a trust, the exception being retirement accounts like IRAs. Once you transfer the assets to the trust, you will no longer have ownership of the house or the money. It has been given away. In the same way you would have given it directly to a child, but instead to a child, you have given it to your trust. So you give up ownership of the asset. The trustee, usually one or more of your kids, is the manager of your trust. The kids do not actually own anything until you pass away. These trusts are irrevocable, so you have very limited right to get the trust assets back whenever you want. Now, I will tell you there are ways to get the assets out of an irrevocable trust. Even though the word irrevocable sounds very ominous, there are ways to remove assets from an irrevocable trust and have them transferred back to the people who set them up, in this case, Stella and George. Now, if Stella and George want to sell their home, they certainly could. The trustee of their trust would arrange the paperwork for the sale, and the proceeds would come back into the trust. Stella and George could then have the trust perhaps buy a new home, or maybe if they didn't want to relocate to a home, they could go to a senior living environment. I have clients paying an entrance fee to enter in continuing care retirement communities, and their trust actually pays for that entrance fee. If they're just going to have the sale proceeds invested, the trustee can then put the money into a bank account or other mutual fund with a financial advisor. The trust itself says that Stella and George get to live there for the rest of their lifetime. They can't be kicked out. They're going to live there for the rest of their days. And because their kids don't actually own the house, the trust owns it, the kids cannot just arbitrarily decide to remove Stella and George from the property. It's only when Stella and George are deceased that the trust ends, and there's a section of the trust that says the kids shall inherit the home upon their Stella and George passing, just like it would in a will. Some of the benefits of the asset protection planning we're using an irrevocable trust. Heather, the first one, we just mentioned that the big D's. How does this trust protect Stella and George?
It avoids exposing the home to the creditors of the children. Both Carl and Doug, as we have learned, have creditor issues, and by keeping the home out of their names, the home can be protected from lawsuits and creditors of these two children.
So I mentioned the trust being like a person on paper is a separate entity. It's a separate entity, and it doesn't involve the kids' lives. And the kids' social security numbers and the kids' names never show up on the title to the home. It is the trust itself that owns the home until Stella and George have passed away. So Carl can get divorced. Doug could be sued by people. It doesn't really matter. It's not going to affect the title to the home of Stella and George. And there's a better tax outcome through using a trust. There will be inheritance tax due at the death of Stella and George. But as I mentioned, the tax is going to be 4.5% here in Pennsylvania if they leave the home to the kids. This will avoid the kids having to pay the much higher capital gains tax if the property is sold during Stella and George's lifetime. If the property is sold during Stella and George's lifetime while it's in the trust, it will be entitled to the exemption from capital gains tax. You and I, if we own our own homes, we can exempt our own homes from capital gains tax. And it's the same result if Stella and George have put their home into an irrevocable grantor trust. It is exempt from the capital gains tax by virtue of the trust that they created owning and selling the home. So a better tax result from the perspective of Stella and George. Although the 4.5% tax will be paid at death, you'll avoid that capital gains tax problem that you typically have if you turn your home over to your kids. So Heather, what about the nursing home protection concern? That was Stella's first concern she had.
So because ownership of the home would be transferred to the trust, the home is protected from nursing home costs after the 5-year look-back period.
Okay, so this is the same result as if you transferred it outright to the kids. And of course, if you give it outright to the kids, you got the big D's you're worried about. You're worried about the tax problems. But here, when you transfer the asset to an irrevocable trust, you don't have those concerns. Plus, you've still got the 5-year look-back period operating. You don't have ownership of it anymore. So you've got the ability to protect the home from nursing home costs down the road. And as I mentioned, you could sell the home. The trustee would put the home up for sale, and the money would come into the trust. And so the proceeds would be protected from nursing home costs. So the neighbor Lois, remember that scenario, if Lois had put her home into the trust, well, before she entered the nursing home, the kids had to sell it. The money from the sale of the home would have been in Lois's trust and would not have need to have been spent on her nursing home costs. And lastly, the trust protects Stella and George from getting kicked out of their home because the trust says you can't be removed from your own home. You have to pay the taxes and utilities and maintain it, but you can't be removed. So there's some protections there for Stella and George, and also for Stacy, who they want to ultimately protect that home for. Now, beyond just protecting the home for Stella and George, they raised all these concerns about their kids, Stacy being at the top of their list. She needs a place to live, but they want to treat their kids equally. And Carl, of course, has this pending divorce. Doug has some drug issues and creditors, so they want all those issues protected, or rather addressed in their estate plan. And so in the body of their asset protection trust, they can address these issues. They can say, at my death, at the death of Stella and George, here's how I want the proceeds of the trust to be paid out. The answer to address Stacy's concern is to first state in the body of the trust that a life estate will be created for Stacy in the home when Stella and George are deceased. This is a provision that basically says that Stacy has the right to live in the home as long as she wants, provided she pays all the taxes and utilities. And if she no longer wants to live there or upon her death, the home goes up for sale and the proceeds are divided equally between Stacy, Carl, and Doug. So this provision in the body of their estate plan protects Stacy and also equalizes the distribution of the sale proceeds between all of the kids. Now, with regard to Carl and Doug's creditors, Stella and George could create spendthrift trusts in their estate plan for each of their kids. They could say, at the time of my death, any money passing to Carl and Doug shall go into a trust for them. And that money will be protected from their creditors. Creditors won't be able to sue Carl, like his ex-wife, or Doug's creditors could not sue him for money from his spendthrift trust. It's a protected trust for the benefit of Carl or Doug. They wouldn't have actual control of the money, and therefore their creditors could not access their trust. So those are estate planning provisions that you can build either into a will, or in my suggestion here, create an asset protection trust to protect Stella and George's house, and in the body of that trust, set forth what will happen to each one of the shares of the kids, as well as address Stacy's concerns about living there the rest of her lifetime. And there's the Spendthrift Trust provision. And you can name a person to manage money for Doug and Carl, or a financial institution like a bank to be the trustee. And we often do that when we have the Spendthrift Trust because sometimes kids like Doug have various issues and it's challenging to put another sibling in charge of managing the money for the child with some drug issues. So be careful about transferring outright property transferring property outright to a child. There may be circumstances where it makes total sense to do so, but oftentimes there are risks that can be avoided by using an asset protection trust. If you want to learn more about this sort of planning, do visit our website at paelderlaw.com. There are many blog articles out there about the Medicaid program, life estates, asset protection trusts, and so on. Thank you so much for attending. I'm Matthew Parker on behalf of Heather Kohler. Goodbye.